We're going to go ahead and get started. I'm going to turn the time over to Steve Randall, who is our president, and he's going to run the business portion of the meeting, after which we'll do the annual report and then the legal seminar. So welcome.
Paul normally says the oldest property manager alive is when he does that. So let me just ask you a question. How many have been in property management or owners of properties for 5 years or less? So you're a little bit new. 3 years. Just the first year. Anybody for just the first year? First year. And you look normal too, so I can tell you that property management, being a landlord, being involved with the Utah Apartment Association is just the best thing that you can possibly do. Of all the businesses, and we've bought and sold many businesses over the years, this is the one, if I was young again, I would start it. It is just amazing. And we just want to thank Paul and the staff for the great work which they do. Now we know you're here to listen to the legal seminar. We have a little bit of business. This is our annual general meeting that way. So we need to present some names to the membership for your approval. So if it's all right, if I can run this. I don't think we want the annual report. Okay. And if I could, Mel, would you mind? They'd rather hear your voice than mine. Would you just mind reading the names? You don't need to read the companies.
Okay.
Okay?
Jeremiah Mon, Pat Morse.
Actually, let me start with the current board first.
Okay. Current board of directors.
On the right-hand side,
Casey Keller, Sherry Goss.
Goss.
Shoot, I should have practiced this.
Sorry to put you on the spot.
Is that how you said? Denise Nauman, John Sandberg, Gloria Froer, Cal DeRose, Jennifer
Evident. That's a good one.
I thought that one.
Jennifer here tonight, I'll see her. So.
Candace Meyer, Kirk Colmore, Keith Nilsson, Nikki Meadows, Marina Palmer, Mike
Beyerschmidt,
Reed Hainsworth, Rich Wilcox, and Rick Mears.
And Rick Mears. They're currently serving as the board of directors. Many of these are vendors. Many of these are property owners, small property management companies, and so forth. We would love to have some of you who own just a few properties also serve in that capacity. So if you're interested, just let us know. The new slate of officers and candidates would be Jeremiah Mon, Pat Morse, Jamie Buellman, Melanie Lettingham, Courtney Snyder, Chris Scherer, Steve Randall, Gene Smith, and Peter Harradine. So those are the nominees that we'd like to present for a vote. Is there a motion to sustain these? Is there a second?
Second.
All in favor then of sustaining these officers, would you please say aye? Aye. Are there any opposed? Okay, thank you. Just want to make mention, we have the very best executive director, because we travel around the country to meet with all the executive directors. Paul is so respected. I have to follow him around to be sure he doesn't get hired away by another state that way. I also want to recognize that we have some of our legal counsel here tonight. So, Walt, do you want to just raise your hand? So that this is Walt Merrill, who's up north in Ogden. And then standing in the back is Kurt Cullimore Jr. And Kurt's going to make the presentation tonight. And Jeremy Shorts from Orrin in the blue shirt right there. So these folks put in tons of time to make sure property rights are watched over and that your rights as a landlord are taken care of. So we just want to thank them for their efforts. So, Paul, is there anything else you need me to do?
Nope, thank you. Give him a big round of applause.
We'll turn it over to Paul.
Kelly, James, and Taylor. I'm going to introduce you to the staff. When you call in, I hope you always get a good experience when you call or come in. And that's why we've hired the best and the brightest to help you. Callie, how many years have you worked for with me?
8 years.
8 years. So Callie started when she was 16, and somehow she squeezed in 7 kids over those 8 years. But she's very valuable to us, and many of you deal with her a lot. James, been with us a couple of years. He is our just expert on the phone. When the phone rings, none of us can answer it because James runs as fast as he can. Actually, James cheats. He has this little thing in his ear. He just goes boom, and he answers the call. He loves talking to you. And then Taylor does our education and programming and our creative stuff and designs our stuff like this for us. And give them a big round of applause. Hopefully they're very helpful. So we're going to have them walk around and pass out the annual report. We're going to split them up, and if you've got one, great. If not, we're going to go through this annual report really fast. As you know, the Utah Apartment Association is a nonprofit 501c6 trade association for the purposes of advancing the interests of the rental housing industry. We are Utah's leading advocate for the owners, managers, developers, and service providers to the multifamily and rental housing industries. And in that role, we provide education and advocacy at the government level and also do public relations for the industry. But in order to do those things, we have to run like a business. And so every year we come before you and we make an accounting of our progress and assure you that your money is being used appropriately and effectively. So the 2013 annual report is that we have exactly 3,200 members at this point in the calendar. Now, just so you know, it's a little interesting. We're biggest in the summer because then in the fall we kick people off who haven't paid. Okay, we kick them off the island, and then we try to persuade them to come back. A lot of them actually, you'll be surprised, come back. But that being said, we were up about 3,600 in the summer. We're down about 3,200 now. We'll renew those over the next. One thing in association management it just floored me when I first learned this. That associations that send out more than 7 invoices, and some of you get sick of these invoices that we send out, don't you? More than 7, actually your retention ratio goes up a whole 10%. So sometimes, many of you paid in October when the dues first came out, and we appreciate that. Some people don't pay until April, and some people don't even pay until we turn them off in July, and then they pay. But they're happy to be members of the association, and we're fortunate to have so many happy members. Currently, 72,684 units. So you'll notice it's in very small print, but 2960 and 70,710 units last year. We're up 8% so far this year, so we are growing and doing well. 54, just for fun, 54,000 of the units are in buildings 100 units and larger, but 21,000 units are owned by independent owners. Of the 3,200 members, about 2,700 own 10 units or less. So I assume that's the majority of you in this room, and you are the lifeblood of the association. Okay, our revenues from dues have grown, as you can see, over the years. Last year, in 2012, we had a total dues revenue of $520,000. Our budget is a few $100,000 higher than that because we have education revenues and trade show and events and other types of revenues. But just our dues revenue, $520,000. We're on pace this year. We're about $35,000 ahead of last year. We're on pace to be about 8% growth, which we're very pleased with. Much of that is because many of you are very happy members of the association, and you tell your friends and family and people that get into rental property about the association. We appreciate that. Keep it up. Okay, our PAC. What's our PAC? Political Action Committee. What do we spend that on? Knitting Club, right? No, we spend that on government affairs. And we just went through a municipal election cycle where the mayors and the city councils were elected. And we were able to support candidates who are friendly to rental housing. Okay? And sometimes oppose candidates who aren't. We did pretty good. Next year is a legislative cycle. So you have the legislature that will all be up, and some of the state offices. And we do very well at the legislature. Do you know about 40% of legislators are rental property owners themselves. I don't know how we could have a better situation. So we support and give a lot of money to those people, not because we're buying influence, but because we're supporting people who already feel the same way you do, and who are already persuadable when we go in and explain, if you pass this law, this is what will happen to rental businesses and your own rental business. And they say, oh yeah, we don't want to allow that. So we have a very good track record because we do so well on raising money. And if you contribute to the PAC, thank you. If you don't, would you consider doing it? $50 if you're a small owner, $100. Or some people give $1,000 or $500, depending on the size of their business. Would you consider it? We use that money very wisely. We had a political luncheon last week where President Niederhauser, who is the president of the Senate, spoke to us. And President Niederhauser was somebody that we have been funding ever since he got in the legislature, when he was just a senator. And his race in Sandy's district, his first race cost him $250,000 to be elected. And I handed him another $1,000 check last week. He's very grateful to the association for supporting him. Do you think that anytime I need something from the Senate president that he'll take my call? Yeah. And you know why? Because the collective pooling, if you will, of our influence is more powerful than if 10 of us had given him $100. Does that make sense? Us giving them a big check, oh yeah, I need to pay attention to the apartment association. And by the way, he already is a real estate guy, a developer, a realtor. He's been on our team for years. We never have to persuade him. We just say, yeah, this isn't good for us and this isn't good for us. He goes, oh yeah, I already feel that way. What do you want me to do about it? Okay? True story. One day I pick up the phone during the legislative session, and it's Senator Niederhauser, and he's on the Senate floor. And he says to me in a whisper, Paul. I say, hi, Senator Niederhauser, because I recognize the number on the caller ID. He says, I'm on the Senate floor right now. And we've just moved up debate of the immigration bill that affects the rental housing industry. And I'm very concerned about it, and I wonder if you maybe have written an amendment to make this bill better. And I said, as a matter of fact, I have. Kirk Collimore and some of the others that work with us, we had our lobbyists, we had already got it ready. We just didn't think it was today. We thought it was tomorrow. He calls us. I texted it to him. And literally 10 minutes later on the floor of the Senate, I'm watching. And if you've never done this, you can watch it online while the Senate's in session, or you can go up there. But I'm watching it online this particular day. He gets on the floor, makes a motion to insert our language, the Apartment Association's language, and take a bad bill that said it's illegal to rent to illegal aliens. Well, gosh, some of us don't do it on purpose. And say, instead, it's illegal to knowingly, with intent to violate federal immigration law, shelter or harbor an illegal for commercial gain. Is that much better? Yeah, I mean, I wrote it. I don't even know for sure what it means. But I think what it means is, in the state of Utah, intent has to be proven to throw the book at a landlord. And so far, no landlord has been hassled about this. And as long as you're doing your best to figure out if they're legal to be in the country or not, you're fine. So that's the kind of friends that this money helps keep in office. Do we want him there forever? Yes. Okay, and in House leadership, we have Greg Hughes, who's a landlord in Salt Lake City. And he comes to me all the time. He says, I'm so glad you guys are up here, because as a legislator, I can go to my colleagues and I can say, do this or do that. But I don't always have to. I can say, hey, apartment association, go talk to this person or go talk to this person. And together, he can go talk to other people. We get more done to protect our industry. So this year, we're on track to eclipse last year's goal, even though it doesn't seem like it. Most of our money comes in at the end of the year, and we're on track. But if you have an opportunity to give, we'd sure appreciate it. Okay, here's our board. Just one quick thing about boards. Boards help administer the association and make sure it's directed the way that you want it to be. If you notice this, you have a broad spectrum of people. Some of them own a few rentals. Some of them own 15,000 rentals. Some of them are attorneys. Some of them are vendors. It's a good balance so that we can make sure that we as an association are protecting everybody's interests. And it is great to work with these great volunteers who don't get paid anything, and they spend a lot of time, especially Steve Randall. Steve, how many times are you going to be here this week? He may have stepped back into the office. I think he's going to be here 4 times this week. That's a lot of time for somebody with a real job trying to make money in the real estate business to volunteer and to come do things for you. So they really do a good job. Okay, so that is the end of our slideshow. And, does anybody have any questions about the association? Not legal questions, because you'll have those answered in a minute. The association, how we operate, the board, anything like that? Yeah.
I just had a question. Why was the size of the board reduced so much? It's only half the size it was last year.
Yeah, question is, why is the size of the board steadily decreasing? And the answer is, it's part of a design, okay? The people in the industry, and you may not know this, but there's hundreds of thousands of people that work in the industry I work in, and that's not the real estate industry. I mean, I'm an expert in the real estate industry, but I'm in the association management industry, and I actually have a certification of the Certified Association Executive, lots of training how associations work. And associations all over the country are reducing the size of their boards on purpose because it's a little easier to operate if you have a little bit smaller, more devoted boards. So for instance, we had 33 people on. If 20 of them come to a meeting, that's a good month. Wouldn't you rather have maybe a 10-member board where 9 of them come all the time and understand all your issues and are devoted to have the time? And so that's why we're reducing the size of the board. It's strategic and on purpose. But there are committees. So if you would like, get with Callie in the back and she can put you on a committee and you can be involved and you can help in another capacity. You don't all have to be on the board to contribute to the association.
What are you going to reduce it to?
Our target is 15. We're at 23 or 24 this year. We're down from about 32. So our target is within a year or two to be within 15.
What's the balance between individual owners and...
Yeah, good question. What's the balance between apartments and individual owners? We try to rotate a president from the large communities or the small owners every other year. So as you saw, about 70,000 units, the majority obviously in the big complexes, but the majority of members, 2,700 of the 3,200 members, are the small owners. So we try to follow, don't quote me on this, because usually you wouldn't follow anything Congress does. But the framers of the Constitution came up with what they called the Great Compromise. And what was it? Do you remember?
Senate in the House.
The Senate and the House. One was based representation based on population. One was based on, just the state. So we try to do the same thing. We try to give everybody equal opportunity to have their input, and so we rotate every other year. We only allow 1/3 to be vendors, and we try to keep, of the 2/3 that are owners, we try to keep about half big and half smaller. Any other questions? There's great questions. Okay, well, let's have Kirk Cullimore Jr. come up. And Kirk, would you like a microphone?
I'll just try to talk loud.
Okay, Kirk's going to project, and if you can't hear him in the back, just raise your hand and he'll speak up a little. I've known Kirk Cullimore for a long time. One thing that you may not know about Kirk Cullimore Jr. is he is an expert concert pianist. Come stand up here. You don't have to sit down. Okay? I remember years ago he plays piano for us at the holiday parties that we do and the awards ceremony. So he's extremely talented musician, but he was so enamored by the law, loves the law, that he also went to law school in his spare time when he wasn't practicing the music, and became a very respected attorney. Works for his law firm. You probably know Kirk Sr., who's built a law firm in the state of Utah representing landlords. So I'll just turn the time over to him. You're going to like what he has to say. Thanks.
So Paul's asked me to address legal issues that affect landlords in the property management business. But I want to make this an open forum, so feel free to ask any questions as we go through this, and we'll just try to do our best to answer it and get through as much material as we can. So some of the topics that I was thinking we can address are, obviously when you need an attorney in this business, the number one reason is evictions, right? So we'll talk about evictions, but some of the other issues are collections. I see a lot of issues with collections. We think about the evictions because those are difficult. Those are difficult tenants that we're trying to get rid of. But I would guess that more of you guys have tenants that just skip or leave or finish their tenancy owing you money than the ones that you actually have to evict. And so there's issues related to those collections as well that we can talk about. Of course, there's always fair housing. There's the Utah Fit Premises Act. And then there's abandonment issues that we can talk about, whether that means the premises being abandoned or abandoned property and how to properly dispose of that. So let's, again, if you have questions on any of those, feel free to just raise your hand and we'll go after that. But we're going to start with evictions today. So the way to begin an eviction in the state of Utah is through termination notices. Let's try to list all the termination notices. There's 4 right off the top of my head. Really, I think that's all 4 of them. So, what's the first, most common one? The pay or vacate. 3-day pay or vacate, right? What else do we have?
End of term.
End of term. End of term is one.
Comply or vacate.
A comply, a nuisance, a comply or vacate. And the last one is kind of like a nuisance or a comply or vacate, but you can do a 3-day notice to vacate, particularly for criminal activity or sustained nuisances or something, something that may not be able to be remedied, that you would do a comply or vacate. So let's jump to the 3-day pay or vacate first, because that's most important, or that's what will come into practice most for you guys. So any eviction action for non-payment of rent starts with this notice. So this is a legal notice, and state law requires that you have specific things on it so that it conforms to law. If you add things to your notice that are improper or not provided for in your lease, it can invalidate the notice, which will require you potentially to have to start the eviction action over. So non-payment of rent notice should include the rent amount that is owed and only the rent amount. Rent being rent, late fees. If your lease provides for utilities, you can include that, or other fees due under the lease. What should not be included on 3-day pay or vacate? Damages are often, security deposits, damages. Fines are usually not proper on a 3-day pay or vacate. I've seen courts that have invalidated these notices because there are improper amounts on there. Now, if somebody breaks your window or causes damage to your premises, are they liable for that? Absolutely, but it's not rent, right? So that would be more of a comply or vacate type issue. Security deposits. I've seen courts kick out notices because we've included security deposits, and this has come up a lot for me actually recently, where a 3-day pay or vacate will say, well, they owe me $2,000. Well, $1,000 of it is rent, and $1,000 of it is the security deposit because you agreed that they could pay the security deposit over time and then they didn't pay it. Well, certainly that's an issue that they got to remedy, but it's not rent. And I've seen courts decide that that's not a proper notice because you can't ask for that as rent because it was a security deposit. So, assuming that we have the 3-day pay or vacate and it's valid, is it 3 business days or 3 calendar days? I heard some of both, but it is calendar days. Okay, so I typically advise my clients that today's a Tuesday. If you posted it today, we're going to give them Wednesday, Thursday, Friday. However, if you posted it on Friday, theoretically we can, they've got Saturday, Sunday, and Monday, and we could potentially start the eviction action on Tuesday, okay? So they have 3 calendar days to start that. Once you start that, we can file a lawsuit. And in Utah, we have an expedited procedure for evictions. So it can move a lot quicker than your typical case, especially on 3-day pay or vacates. Once they're served with the lawsuit, they have 3 business days now to respond to that lawsuit. If they do not respond, you can get a default judgment and an order of restitution, which will generally require them to vacate the premises within 72 hours after that notice has been posted. So it can move pretty quick here in Utah. If they do file an answer within those 3 days, then you can request what's called an immediate occupancy hearing and get in front of the judge to make a determination of who gets possession of the premises. And assuming your 3-day pay or vacate notice was correct, generally there's not much to decide there if they owe the rent, and you can be awarded a 72-hour order of restitution at that time. That's kind of breezing through the eviction process on 3-day pay or vacates. But do you have any questions on that?
Going back to saying you can't put fines on if you have a late fee or those kind of things, is that a fine?
Late fee is not, no, late fee is appropriate. You can
Okay.
put late fees on the 3-day pay or vacates.
And you can also put, and then after that time, $5 per day.
Correct.
Okay,
Yeah, so long as the lease provides for it, of course. Did everybody hear that question? Late fees are not fines. You can put late fees on the 3-day pay or vacates. And if it means $5 a day, then you can put on the notice and a continuing $5 a day late fee. Okay.
If you have those 3 days, and then you as the owner do not take any action for, because you're kind of benevolent, I guess, does that negate that, invalidate that?
That's a good question. So the question is, if you post a 3-day pay or vacate and then you decide to not immediately initiate a lawsuit after those 3 days and you decide to give them a little bit of time, does that invalidate the notice? The answer is no. You can hang on to that notice, and if they give you an excuse that you find is reasonable and you decide that, hey, that's a legitimate business reason why I'm going to allow you to try to work this out, then you can absolutely do that. The question then becomes, how long do you allow that? I advise my clients, I don't like to see notices that are more than 3 weeks old or so. So if you're giving them more than 3 weeks, I personally would probably advise you to post a new notice. Depending on when you posted it anyways, there may be new rent or new fees associated with that notice that you need to include anyways. Go ahead.
They owe you $2,000 and they pay you $1,000, what do you do?
So this is going to be up to you. So the question is, they owe you $2,000, you put $2,000 on the notice, and then they come and try to tender $1,000 to you. What do? Depends on how bad you want them out, and depends on how bad you want that $1,000. If you take the $1,000, you just invalidated the notice.
But you could put down another one.
You can take the $1,000, immediately post another notice for just the $1,000 that's left remaining. So if you need the $1,000 worse than you need them out, take the $1,000 and post a new notice. But just be aware that if you take any money after you've posted that notice, let me correct that. You're going to invalidate the notice anytime you take money. If you take the money you're obligated to take payment in full within 3 days if you've posted that, because that's their cure period under state law, and they can do that. Once the 3 days is up, you can deem the lease terminated, and you have no obligation to take monies anymore. And you can just say, I don't care, I want you out of here. They're still going to owe you the money, but we just proceed. You can proceed with the eviction, and then worry about collecting the funds through the litigation process. Okay. So moving to a comply or vacate. The biggest issue I see with comply or vacate notices is the legitimacy of the nuisance. So you may have neighboring tenants that are complaining about another tenant, and it could be every excuse under the sun. You need to put yourself in the shoes of a judge and decide, is this nuisance rising to a high enough level that I should kick these people out of their home? So everybody has problem tenants at some point, right? We get tired of them and we want to, I'm done dealing with them, but they're paying rent on time and everything like that. So you start nitpicking. If you're nitpicking, that's going to be a difficult case. If there's legitimate concern, if there's legitimate nuisance, then generally I would say let's consult with your attorney and let's talk about it first. Let's figure out a game plan, because the more you can demonstrate to the court that this is an ongoing nuisance and it's been a problem for quite some time, the stronger your case is going to be. So oftentimes, let's say it's a smoking violation, which is one I hear a lot of. I might encourage you to talk to him and put something in writing saying, hey, I've been getting reports about smoking, or I've seen you smoking, or I can smell this. This needs to get remedied immediately, or we're going to have problems. If you can demonstrate that you give them a couple notices before you provide the legal notices, that's going to build a stronger case. There are some things that are easier to prove than others that you may not need that. Another big one on nuisance or compliance issues is if they have an unauthorized occupant. If they've got an unauthorized occupant, you do a comply or vacate, and you can demonstrate to the court that that unauthorized occupant is still living there after the 3 days, that case is a little bit easier. Same with unauthorized pets. Damaging the unit and then failing to repair it. Normally, if somehow they damaged your unit and it was clearly them, and then you assess them to get it fixed and they fail to fix it, and we normally first ask that you invoice them, try to get it paid. If they fail to pay, then you post a comply or vacate saying you got to pay within the 3 days or resolve this with me, otherwise we're moving forward. That's another one that's a little bit easier to prove most of the time. And then criminal activity. If you've got a police report or you've got testimony, then that's another easy way to prove that on that. So the final notice is an end of term notice. So how long do you have under state law to give them an end of term notice? Or under the contract?
30 days.
30 days is the general rule, right? So most of your leases are going to say that either party has to give 30 days to terminate the contract. But generally that means to terminate it at the end of the initial term. So if you do a 1-year lease, before month 11, you want to give them that end of term notice if you don't intend to renew the lease with them. However, if you're in a month-to-month tenancy, state law says you only have to give 15 days. Okay, so you don't have to give 30 days notice.
Even if it's your lease?
If it's, you want to be explicit in your lease that once you move to a month-to-month tenancy that your obligations may change. I know the Utah Apartment Association lease requires that tenants give 30 days notice no matter what, even when it moves to a month-to-month tenancy. But on a month-to-month tenancy, I advise my clients that under state law, we only have to give them 15 days. However, case law and state law would suggest that the end of that term has to be at the end of a lease term, which generally is a calendar month, right? So almost everybody does rent due on the 1st, right? And you're paying for that month's rent from the 1st to the 30th or the 31st. That is a term under your lease, and so generally we suggest a calendar month. So you could give them a notice on the 14th of a month, effective for the end of the month, if they're on a month-to-month tenancy. Okay.
Do both of the parties have to have the same time frame? In other words, could you have a landlord that they have to give you 30 days, but in a contract sense, but you can give them a 15-day?
And that's what the Utah Apartment Association their lease actually says, that the tenant always has to give at least 30 days notice, but once you're on a month-to-month, the landlord could potentially just give 15 days. Some judges don't think that equitable, but if it's in the lease, then so be it. I do have some clients that require their tenants to give 60 days notice, even once they go month-to-month. Judges really kind of frown on that one because once it's in a month-to-month tenancy, they're saying you can change the terms of the tenancy with just 30 days notice, but these guys have to give 60 days notice to get out, so it becomes a little bit more iffy if you stretch the timeline, but yes, you can. Yep.
I had a question. I had a tenant that this summer his lease was up, and so I was needing him to sign a new lease, and I'm a new property owner or whatever, and so he's like, well, I think I'm going to be moving out this year, so I just want to go month to month. And I'm like, well, I'd really rather you signed up a year lease so that, I had some security and had some notice on where you were going to move and stuff. And he's like, because if you knew more about property management, you'd know that I could get out of this pretty easily. And I was like, and of course I'm naive enough, I went, okay, whatever, and went to month. But I knew it because I wasn't aware of my situation, and it was my lack of ignorance, and I was on the spot. But I'd like to know, is it really that easy for them to get out of a year lease if, they negligence or something to get out really easily, or?
Generally, no. The laws in Utah are slanted pretty favorably to landlords, and then unless you get a really bad lease, your lease is going to protect you too. The lease is there, so both parties understand what the agreement is, but it's supposed to protect both parties, but most of the good drafted leases really protect the landlords, right? So yeah, you can definitely hold their feet to the fire on that year lease, and it's, more often than not, it's beneficial to have them sign that year lease. So yeah, it's not as easy as he thinks to get out of a year-long obligation under the lease.
Can you write in minimum 1 year instead of the time period from June to June?
Yeah, the question is, can you write in for the term minimum of 1 year instead of June to June? You can, I mean, you know, you can do almost whatever you want in contract, but the more explicit and the more specific you can be, the better. So
Put the date.
I would advise putting the dates, yes.
If you were to suspect drug selling going on, and other tenants in the building suspected as well, can you do anything about it, or should you notify law enforcement? Does law enforcement get involved when say a landlord suspects it?
So the question is, what can you do about suspected drug activity in one of your units, particularly if other tenants suspect the drug activity as well? You can call the police, but they're not going to do much until they have, you know, some sort of probable cause or evidence to pursue the matter. And so if it's just suspicion, I mean, we all know what it is. You know, lots of random people showing up at various times, you know, that you never see. They may show up once and never see them again, or once every few months, or, you know, these guys have cash a lot of the times or whatnot. And so that, you know, there's a lot of red flags about drug activity. So it really is a case-by-case basis. I can tell you in civil matters it's different than criminal. So, you know, if you're going to convict this guy for being a drug dealer or using drugs or something like that, you have to be able to prove beyond reasonable doubt that he is dealing drugs or using drugs. In a civil matter, you just have to show that by preponderance of the evidence, it's more likely than not that it's going on. So if you can kind of build your case, and we can demonstrate that it's more likely than not that criminal activity is going on in there, illegal drug activity, you can probably prevail on an action to evict him. Now, again, like I said, that's going to be a case-by-case basis, and I would recommend calling counsel to kind of prepare that case. You don't just want to willy-nilly file it, although depending on the circumstance, you may just want to post some notices on there and see if you can't scare him out of there or something. You know? So, but yes.
Follow up on possible problems that someone is doing drugs. Let's say one tenant has been putting meth, and then the apartment has been contaminated, and then the next tenant, say, he or she has health problems as a result of you were not aware of that meth being used by a previous tenant. Where does your liability
Did everybody get? So the question is, you have a tenant that was using methamphetamines or cooking methamphetamines or something in your unit. For whatever reason, you were not aware of it. Somebody new moves in, and maybe they're particularly susceptible to meth contamination, and so they have potentially health problems and stuff like that. Yeah, you're probably going to be liable to the second tenant. However, the first tenant ultimately should be liable, but we're going to have to prove that it was them and all that. So, if the second tenant requests a meth contamination and they feel like there's reasonable cause that you should do that, then yeah, I would recommend doing the meth test. Just as a side note, I would recommend doing a self-kit and sending it to the lab and getting test results. If you hire a remediation company, oftentimes if they get results that are above the legal limit, which it is not hard to get above the legal limit for meth contamination, they report it to the health department. The health department comes in and they've got a whole laundry list of stuff you have to do to fully remediate your unit, and it's going to cost you a few $1,000s at a minimum. So while obviously we're concerned about the health of our tenants, and I don't want to encourage you to, maintain meth units or anything like that, oftentimes trying to solve the problem yourself would be better, and maybe trying to find a solution for that tenant would be your best bet to mitigate your damages. And then if you can prove that it was in fact a previous tenant, you potentially have a claim against them. Now, whether that claim is collectible or whether you can find them is a different story, but ultimately the person who caused the contamination is liable. If it wasn't caught and somebody else is in there down the road, you're going to be liable to get that fixed.
So could you give them a nuisance notice or a 3-day suspicion?
For meth contamination?
Yeah.
Sure. Yeah. Whether we proceed on that notice or not is going to depend on what kind of evidence you have to support it. But you can, so long as you aren't harassing them just to harass them, you can give them a notice if there's drug activity going on in there.
Where do you get a test to do?
Does anybody know? I've had some clients get some tests recently.
Home inspectors.
Yeah, home inspectors. So I had a client recently who called a meth testing company, and they told him where to get a kit. Problem is, then you get all the input from him, and he's kind of, now you're kind of on his radar, and if you can avoid that, sometimes it's better because they've got a vested interest in finding meth contamination and coming in and do the remediation, right? So, but they can definitely point you to where those test kits are, and it's I think it's only like $40. You buy it, you swab about this big area in 4 different parts of your house, then you send the kit into a lab, and the lab will come back and tell you how much it is.
Is that legal to do while the resident is still there, so you have evidence of the meth contamination? Or is that an invasion of their privacy?
Well, a lot of that's going to be dictated by the terms of your lease. So if you're using the apartment association lease, absolutely you can do that. You can go in there and test, and I know a lot of leases will say that the right to test a premises is solely, is exclusively with the landlord. So they shouldn't be able to just go out and test it with whoever they want or do it themselves and all this. If they have a suspicion of contamination or anything like that, they need to come to you so that you can do the proper test and take the remediation action that is best for you. So that's the kind of leases I would look for.
So, your advice in that same scenario, if you suspect that there is activity and you do your quarterly inspection or whatever, if you're using an association lease, you're within your rights to then test at that time when you do your quarterly inspection.
Sure.
And then that would give you the proof that you would need to do a...
Yeah, absolutely. Yeah, if you've got suspicion, I would just say, give them notice, say, hey, I've come in and do an inspection, and if you decide to test during that inspection, then so be it. Is there another question?
Do you have to tell them you're coming in to test their walls, because they might wash their walls by the time you get there?
Just do an inspection.
Yeah,
Can you just,
I wouldn't say I'm coming in to do a meth inspection if you suspect they're doing meth.
I mean, can you just bring our kit with us and do it when we're doing an
Sure.
inspection?
Yeah.
Without telling them what we're,
Yeah.
okay.
Yep. Yeah, absolutely. Totally. I apologize. I can't hear anything you're saying.
A lot of times we suspect drug activity, we call the police, all they're going to say, we don't have probable cause.
Right. So she's saying a lot of times if you call the police, they're going to tell you they don't have probable cause to come in and inspect the premises, which is absolutely true. Do you as landlords need probable cause? No, you just got to abide by the terms of your lease or state law. So generally 24 hours notice is going to be sufficient to get in there and inspect the premises.
What do you do if they don't let you in?
That's a compliance issue. They don't let you in, they're not complying with the lease. You can post a 3-day comply or vacate, and they've got to let you in within the 3 days or they're failing to comply. All right, since the law's changed on this in this past year, let's jump over to abandonment really quick. So there's 2 issues with abandonment. You've got whether your premises is abandoned and somebody skipped on you, what do you do? And then if there's property left behind, what do you do about that? Whether it's because you evicted them, whether they skipped, whether they've moved out and just left stuff there. So how do we address that? So first off, there's 2 ways to determine if the premises is abandoned, okay? The first way, the most obvious way, is if you go in there and there's nothing there. They've left, there's no living stuff in there, there might be some garbage, there might be some rotten food in the fridge or something like that. They've clearly left, and you can deem the place abandoned, change the locks, and turn it over, and that should be sufficient. The other way is, maybe they haven't paid rent, so on the 5th you go over and knock, they're not there, maybe you decide to open it up and see what's going on. There's stuff there, but they're not there. You post a 3-day pay or vacate, they don't respond. You're not sure if they're there, so if we start an eviction action, we may not be able to get them served if they're not living there. So you check again, State law provides that if 15 days have gone by and you have no reason to know where they are and rent has gone unpaid, you can deem the premises abandoned. Okay? So if rent's been paid and you still don't know where they are, it doesn't matter, right? So it's only if rent's gone unpaid and 15 days.
Clarify like that first case, you say you go in there, everything's gone, but they're still current on the rent.
If they're current on the rent, then I wouldn't. Yeah, I mean, that's going to come down to circumstances again. You know, if it's the 25th of the month and the place is completely abandoned, but they paid rent, I'd probably give it 5 or 6 days and see if they pay rent the following month, and and go from there. I mean, if they want to leave the place abandoned and pay rent, your first question should be, what the heck is going on, right? So.
You say no contact for 15 days and the rent is unpaid, or the rent is unpaid for 15 days?
No contact and 15 days has gone by with rent being due, basically.
It was due on the 1st, but you haven't seen him since the middle of the previous month. The 2nd's not good enough.
Right.
You gotta
Wait for the 15 days after, yes.
Right, thanks.
Yep.
I was just gonna say, you can get the police to come and go in with you if you're suspicious of things, because that's what we've had to do, to go into an apartment.
Sure, if you're worried, I would definitely, yeah, if you're worried about something, definitely do that. So the whole abandonment thing, we started an eviction this is a little side story, but I started an eviction one time for a building downtown Salt Lake. This was up on the 10th floor or something. Landlord posted a 3-day pair vacate, rent had gone unpaid. And so they started the eviction action, and a constable tried to serve them a number of times, and we just said, we don't think they're there. Nobody's answering, nothing's going on. So when my constable was there, they got property management, they opened it, and there was nothing in the whole unit except a mattress and a laptop. I don't know, kind of weird. So anyways, we deemed it abandoned, but that's why I go back to, if you haven't heard from them, if the place is abandoned and rent's being paid or something, figure out what's going on, because it might be something shady. So let's talk about property now. So if you deem a premises abandoned, either they've returned the keys, they've vacated, or you have no idea where they are and there's just stuff there, so we can properly deem the place abandoned. What do you do about the property now? Store it or keep it. How long do you have to keep it? 15 days. So the law just changed earlier this year from 30 days down to 15 days. There's some exceptions on what you have to keep. If it's perishables or hazardous material, you do not have to keep that. You can get rid of that. The other exceptions are, well, within the 15 days, if they make a reasonable attempt to get the property, we're going to let them have it. But a reasonable intent may include they've got to pay you for storage and moving costs if you decide to move it. With the exception that we're going to let them get their medications or medical devices, some personal, clothes, if something to live on for a couple days if they need that. The question is, if they still owe rent, can you keep their stuff? Until they pay you. Probably. Whether that's practical or not may be up to you, but check your lease. Utah state law does provide for a landlord's lien, but generally that's through an eviction process that we decide that we're going to keep some of their stuff. But your lease may provide for a contractual lien where you can hang on to their stuff as a security for rents owed. But if you're going to do that, I would strongly recommend consulting with counsel.
But that new law excludes medical devices, clothing, and prescriptions, correct? Like,
Yes.
that you can't keep in lieu of rent.
A reasonable amount of clothing. But yeah, definitely, I mean, we're going to give them back their medical stuff anyways, right? And
Yeah.
we're not trying to kill people, and we're not trying to maim
You
people or
have to give
anything,
that back
so.
no matter what.
Yes. Yeah. Sometimes you may want to. But, so 15 days. So how do we give them notice of this 15 days? State law requires that you have to post a notice and you have to mail it to their last known address. So if this is an eviction or if they've just skipped on you, the last known address is your address, right? But maybe if it's at the end of a tenancy and they left some stuff behind, you're going to post that notice and mail it to either their last known address or the forwarding address that they gave you. And that's when the 15 days starts to run. After that 15 days, you theoretically have no liability for disposing of the property. With that being said, we want to dispose of it in a commercially reasonable fashion. So if the property has value, say electronics, TVs, a couch that's not too trashed or something like that, you may want to, disposing of it in a commercially reasonable fashion may mean trying to get some value out of it through selling it, garage sale, auction, something like that. But then those proceeds need to be applied towards the tenant's account. If it's not of such value that you feel like you need to sell it, you can donate it to the DI, Goodwill, or whatever, something like that. And if it's clearly just junk and garbage, or there's no value and it's not even worth a trip to the DI, then you can just get rid of it.
Do you want to know that certified, or how would you recommend?
The law does not require certified. And if the law doesn't require, I generally don't take the extra measures. Huh?
What would you personally recommend?
I would just mail it. Posting it, the law doesn't say how long you have to post it either. What's one of the inherent problems with posting a notice of abandoned property?
You're telling every thief in town.
Right. You're letting the whole community know, hey, nobody's living here and there's a bunch of stuff in here, right? So how long do we have to post it?
Just 24 hours. No, not
5
even
minutes.
that.
It's up to you, right? The law doesn't specify. So, you know, if it's a property that you can go to a lot, maybe I'd post it in the morning, take it down at night. If you're comfortable with the secured property, maybe you leave it up there for a day or two and hope that the tenants contact you. If you're worried about it, I'd post it, take a picture, and take it down or something. So, yeah.
Can you change the locks so that they cannot come back and get it?
Yes, absolutely. Anytime you're going to deem a premises abandoned, I would recommend changing the locks. And that's going to solve two purposes. One, you've now secured the premises, but two, if it really wasn't abandoned, they've at least got to contact you now to figure out how the heck they're going to get in. And then you can kind of resolve whatever outstanding issues are. It may very well be that you've got to let them back in, but maybe they owe you rent and you say, well, I thought you were gone. How do you plan on taking care of the rent? So I would recommend changing the locks anytime you deem a premises abandoned. Let's jump to, I'll let you guys decide. Fair housing, fit premises, collections. Collections? Okay. All right, so everybody has tenants that, how many of you guys have tenants that leave and you return the full security deposit every time? That's almost unheard of, right? So hopefully it'd be ideal, but so anyways, they're going to leave you. So what are some policies and procedures you can put in place